All right, so let me go ahead and share my screen, and I'm going to go ahead and play the slide from the beginning, okay? All right, so this is what we're going to talk about, guardianships and alternatives to guardianships. So there's a couple of options. Like I said, there is going to be an extensive list on the Probate Court 2 website that we'll talk about towards the end, and that is something that, you know, we'll talk about those, but I'm going to talk about the most popular as far as alternatives to guardianship. So with guardianships are a large part of our docket, and that's a lot of what I did for Catholic Charities. I was the guardianship and probate director of their department. We did a lot with individuals with children with special needs or incapacitated. Let's just say you're a child with a parent with Alzheimer's or dementia, and they never had a power of attorney or wasn't executed correctly, or maybe people aren't recognizing it. They typically will go into the court trying to obtain guardianship over their loved one, as well as someone that may have an intellectual disability or is incapacitated in the other way. It's a young adult that's just turning 18, and their parent needs to get a guardianship over them. And what we look at ourselves. So the way that the law looks at it is they deem everyone to have capacity until the law takes it away. So in other words, a vegetative state, doesn't matter, even if it assumes that they have the same capacity as you or I, until they're deemed incapacitated, until those rights are actually taken away. So what I'm going to talk about is some of the alternatives to guardianships, but also the guardianship process. What is the guardianship process in our court when you don't have any other choice but to get a guardianship? So when I talk about these alternatives to guardianship, you have to understand that these individuals, young adults, they have to be able to understand the documents that they're signing. If they cannot understand the documents that they're signing, they do not need to be having a supported decision-making agreement, powers of attorneys, or anything else that they can physically sign themselves, because they cannot understand those documents. So that's basically, as a parent, what you want to think about is you would think, are they able to legally understand these documents? Do they understand the documents that they're signing? Again, if they cannot understand those documents that they're signing, they should not be signing those documents, okay? A guardianship is more appropriate. So let's just, or other alternatives, but we'll talk about those other alternatives. So I'm just gonna talk about the most popular forms of alternatives to guardianship. So the first one is a supported decision-making agreement. So supporting decision-making means the process of supporting and accommodating an adult with a disability to enable the adult to make life decisions, including where the adult wants to live, the services, supports, medical care they want to receive, who they want to live with, and where the adult wants to work. So when you think about the supported decision-making, it's essentially, let's just say, I'm going to use the example of mom and son. Let's say, for instance, maybe son is high functioning autistic and maybe has anxiety around doing some things for themselves, and would like the help of mom. He can go ahead and enter into a supported decision-making agreement with mom, and mom can assist him in doing these things. Now, however, with that being said, just understand that, again, the choice is going to be son's. So son is allowing mom to help him, and he's signing this agreement for mom to be able to help him do these things, help him get an apartment, help him set up a bank account, help him with whatever he may need. But in the end, ultimately, the decision is up to son. So let's say at some point, son decides, you know, mom's a little overbearing and I don't want to, you know, I don't want anybody to help me. I can do it on my own, whatever it may be. They always have that right to then say they want to revoke that supported decision-making agreement. Okay, so just so that you're aware, just because you are the friend in this process and you're able to make decisions along with them, doesn't mean you're the absolute. So just so that you're aware, that is kind of what you need to think about when you're having a supported decision-making agreement. There are people that I have had, because I have done multiple of them, hundreds and hundreds of these presentations throughout the county, with my work with Catholic Charities and also with my work with, just in the probate courts. And, you know, again, you have to make sure that the individual understands the document that they're signing, okay? Because there are legal consequences if they sign this document and they don't have capacity to. Okay. All right. So when we talk about authorizing the witness, because you have to have a witness. So a supported decision-making agreement must be signed voluntarily and without coercion and undue influence by the adult with a disability and the supporter in the presence of 2 or more subscribing witnesses or a notary. So that's important. So it is a form that's going to have to be completed, and you need to have either 2 or more witnesses or a notary. If it's signed before 2 or more witnesses, they have to be at least 14 years of age. So the reason why I put this information at the bottom, the reporting of suspected abuse, neglect, or exploitation, is unfortunately, there are people that think, I'm just going to get my son who doesn't have capacity, or daughter doesn't have capacity to sign this form, and we don't have to get a guardianship because they signed this. Again, the standard is whether or not they're able to understand the document that they're signing. So if you put it in front of a child that you know full well does not understand the document that they're signing, there are legal consequences to that. I had advised schools before not to recognize those supported decision-making agreements if they knew that the child did not have capacity, right? Because that meant that unfortunately the adult did something that the child shouldn't have, that influenced the child to do something that they shouldn't have done by signing this document. So this section says reporting of suspected abuse, neglect, or exploitation. If a person receives a copy of a supported decision-making agreement or is aware of an existence of a supported decision-making agreement and has cause to believe, again, has cause to believe that the adult with a disability is being abused, neglected, or exploited by the supporter, the person shall report the alleged abuse, neglect, or exploitation to the Department of Family and Protective Services. Again, that would be if they felt that, you know, that the disabled individual was being taken advantage of. So the next thing I'm going to talk about is powers of attorney. So what is a durable power of attorney? The durable power of attorney is going to be a document that's used to appoint a trusted person as your agent for specific financial and property transactions that you choose. Again, with a power of attorney, the person has to have capacity in order to sign this document. So they have to be aware, understand the document that they're signing. Again, that cannot be someone that lacks capacity or doesn't fully understand that the document that they're signing, because again, that would be an abuse by the person that is coercing them into signing this document. So you want to make sure, again, if your child is able to understand these documents, these again are alternatives to guardianships, but if they cannot understand these types of documents or these kind of legal matters, you want to look into whether or not a guardianship is more appropriate. So let's see, you give powers such as to buy or sell real property or to manage your financial account. This gives your agent the legal authority to act in your place if you have limited mobility or become incapacitated and can't do things for yourself. So the durable power of attorney, you have 2 options. It can either come into effect when you lose capacity, or it can come into effect the day that you sign it. So if your child is going to sign a durable power of attorney, that is they probably want it to come into effect the day that they sign it, so that you can be able to assist them with opening up bank accounts, you know, whatever, purchasing cars, whatever it may be. You would be able to step in their shoes and do these things for them. Let's see. The agent has a lot of A through M. If the signer, let's say the child says, I want mom to be able to help me or to be able to do all these things on my behalf, they can select A through M. They can also limit it as much as possible. So they can say, well, I want mom to be able to open a bank account, but I don't want her to be able to deal with tax matters on my behalf. They absolutely can do that. So I'm just going to talk a little bit about the powers granted to the agent. Real property transactions, tangible personal property transactions, stock and bonds, commodity and options, banking and other financial transactions, business operating transactions, insurance and annuity, estate trusts, or other beneficiary transactions, claims and litigation, personal and family maintenance, benefits from social, that's important. So that means that you can do things on their behalf. You can talk to Social Security, Medicare, Medicaid, anybody else that you need to talk to in order to apply for and receive benefits on their behalf. And retirement plan and tax matters. Again, they can make this as broad as they want and give mom A through M all those powers to be able to do everything, that she wants on their behalf, or they can restrict it. They can also put in a certain time limit. So let's just say, and I do see this with individuals that are going out of town. So let's say they're going out of town and they don't know if something will happen to them and they want to go ahead and sign a power of attorney. They can limit it to, it's expiring within 6 months. So there's a lot that you can do with the power of attorney to restrict the agent's access. But oftentimes what we see, especially in these types of situations, is they have the agent be able to do everything A through M on their behalf. Now, again, it's so important because when you appoint an agent, they have so much power. They step into the individual's shoes and they can do everything on that person's behalf. So in other words, even if, let's just say I have one with my mother and I say that she's able to do these things today on my behalf, she's able to go into a bank account right now without me and open up a bank account on my behalf. She's able to talk to Social Security on my behalf. Hey, she's able to apply for credit cards on my behalf today. She's able to do all those things without creditors or whoever it may be having to actually talk to me. So it's really, really important that that the individual that's signing this power of attorney understand this document. Again, they have to understand the document that they're signing, because what they're doing is they're basically giving this person the absolute right to step into their shoes and be able to do things on their behalf. So it's super duper important that they trust this individual and they understand the powers and the roles that they're giving this individual, because we see a lot of abuse for powers of attorneys just in general. So again, it's very, very important. And what I stress not to just, people that they're giving powers to their parents, but also to parents that are doing it on, giving their child, making their child the agent. That you have to understand that now that you made them the agent, they can do all of these things on your behalf. They don't need to talk to anyone else. They can just go into a bank, open a bank account, and that's a done deal. So you just need to make sure that you absolutely trust the individuals that you are making your agent. So, oops, I think I did previous, hang on. Let's see. Oh, okay. So a medical power of attorney. So a medical power of attorney is signed by a competent adult, which is called the principal, who does decisions on their behalf with an agent that they would choose to make medical decisions on their behalf. Now, this is a little bit different. People get confused with medical powers of attorneys. They think that just because you have a medical power of attorney, you can now make decisions on your child's health care and do all of these things. Unlike the durable power of attorney, the durable power of attorney, when I talked about it, I said it can either come into effect the day that you sign it, it depends on what you choose, or the day that you actually become incapacitated. Now, with a durable power of attorney, we talk about the day you become incapacitated. Let's just say the day that if you get into a car accident, you no longer make decisions on your own, or you get Alzheimer's, dementia, whatever it may be. That's when you talk about incapacitation kicking in, and you can now use the agent can use the power of attorney. When you select that option that you want it to take effect when you become incapacitated, you cannot just walk into a bank and say, I'm now taking over mom's accounts, I'm her agent, and she's incapacitated. No, they're going to require proof. So they're going to require some sort of proof, whether it's a doctor's note or whatever it may be, that the individual is actually incapacitated, because of course the bank or whoever it may be doesn't want to take that liability on. So now with the powers of attorney as a medical power of attorney, it's similar in the sense that it actually doesn't take effect until the person is deemed incapacitated. So your child may sign over a medical power of attorney and make you the agent. That doesn't mean you get to step in their shoes and make medical decisions for them anymore, or at that time. It only takes effect when that person becomes incapacitated, when that person is in a coma, when that person, when something happens to that person where they can't make medical decisions for themselves. Otherwise, they're always going to be able to make medical decisions for themselves as long as they're able to do so. So the power is granted to the agent. Under a medical power of attorney, an agent is given a wide latitude when consenting to treatment on the principal's behalf. Essentially, the agent steps into the individual's shoes and they start making medical decisions for them, again, once they become incapacitated. So in other words, You know, my husband is the agent for my medical power of attorney. If I were to get in a car accident, end up in a coma, my husband then, as my medical power of attorney, as the agent, he's going to be able to make decisions on whether or not to keep me on life support, whether or not, you know, what type of treatment I am having. Medical power of attorneys come in that is elderly and they have Alzheimer's, dementia. A lot of times they're going to be able to make decisions at the nursing home regarding their health care. So anything that I could have made for myself regarding my health care, my agent can now make. So it says an agent cannot consent to commitment to a mental institution. Now, with that being said, that's a whole nother commitment process, a whole nother mental health process. Convulsive treatment, psychosurgery, abortion, neglect, or comfort care, neglect of comfort care. Let's see. So in the medical power of attorney, just like the financial power of attorney, they are able to limit what the agent does. So in other words, maybe I think my husband can make decisions regarding where I live in a nursing home, but cannot make decisions regarding whether or not I'm removed from life support. I can actually put that in my medical power of attorney, and the doctors have to honor those wishes. Let's see, revocation. So a medical power of attorney may be revoked by notifying either the agent or the principal's physician, orally or in writing. So you don't have to have an actual document that says you can, that says that you're revoking this person as the agent for your medical, or you're revoking the power of attorney, period, or you're also revoking that agent. So you can do that orally with your doctor as well if you don't feel comfortable. You don't feel comfortable with somebody serving as your agent. In addition, so with the medical powers of attorneys, if the principal executed a later medical power of attorney, this is the same with makes a subsequent, they will, it always revokes whatever the former one was, right? It's the same with the will. You make an additional will, it's always going to revoke the one that you previously, it's his or her spouse to the agent, and later gets divorced, they're automatically revoked. So the powers of attorneys, the medical powers of attorneys, and as well as the durable power of attorneys, you're going to have an agent that you're going to list, the first person that you're going to list, and then you're going to list alternatives, okay? Now, in both of these documents, they have co's. I never recommend co on anything. I don't ever recommend even co-executors on wills. Why? Co to me, being an attorney, being an attorney and being a judge and sitting in the spot, co just means fighting. Because if people don't agree, let's just say my husband wants to be able to disconnect me from life support and my mother disagrees, then you've got a huge fight between co's. So I always tell them, I know you love your children and you want to do everything equal and you want to be equal. Well, then on one document, name them the agent and name the other child the alternative. And on the other document, name the other child, you know, so, so I always recommend 2 or 3 alternatives that are alternatives agents that can serve. So in other words, if let's just say you are the parent of that child with a disability and your child signs a power of attorney, durable or medical, they want to think about who they want as the alternative. Because if something were to happen to you and these documents are still existing, or let's just say, heaven forbid, that you both get into an accident and something happens to both of you at the same time, they're going to need to be able to contact that alternative that's on there to be able to step in the shoes and now make decisions, okay? So you always want to have an alternative listed. Let's see. So now I'm going to talk about, so those are the most common that we see, the supported decision-making agreement and the powers of attorneys, but there's a whole nother list that's out there that we'll talk about again at the end. So what I'm going to talk about right now is guardianships, when people apply for guardianships, when it may be appropriate. So again, this is probably about 40% of our docket is what we see with guardianships. So it's a huge amount of our docket. We do see, again, individuals that are incapacitated because of an existing disability. Perhaps they have an intellectual disability or whatever it may be, and they're not able to make decisions on their own. Or it could be someone, a lot of what we see, probably most of what we see in the court actually is individuals with parents with Alzheimer's or dementia that either never cited a power of attorney or for whatever reason, the powers of attorneys aren't being recognized. So I'm going to talk a little bit about guardianships. So the Texas States Code defines an incapacitated person as an adult who, because of a physical or mental condition, is substantially unable to provide food, clothing, shelter, care for their own physical health, manage their own financial affairs for him or herself. So that's the key words I highlighted here: substantially unable to provide those things for themselves. Let's see. Oh, one of my staffers made this, so these all these little things that are popping up. Hang on just a second. Let's see. Okay, types of guardianship and venue. So there's two types of guardianships: guardianships of person, guardianships of the estate. So when you talk about guardianships of the person, it's very simple to think about. It just means that you have guardianship over that person. Any decision that I could have made. So if it's my mom getting guardianship over me, any decision I could have made for myself regarding food, clothing, shelter, or healthcare, my mom can now make a decision on my behalf. The best way to look at it is as a parent of somebody that's under the age of 18, all those decisions you can make for your children regarding their food, clothing, shelter, healthcare, you can continue to make as the guardian of this individual. So that's a guardian of the person. Guardianship of the estate. When we talk about guardianship of the estate, we don't see this very often with young individuals because they don't really have an estate. So we're talking about money. We're talking about real property. We're talking about bank accounts, Social Security, sorry, not Social Security, bank accounts, retirement funds, whatever it may be. When we talk about Social Security, just because your child is receiving Social Security doesn't mean that they can, hang on, I'm hearing something. Oh, hang on just a second. I think I might have both English and Spanish on English only, though. I don't know why. About guardianship of the estate. Hang on, let me see. Guardianship of the estate. We talk about if somebody has an estate. So if you have a child that, let's just say we've seen children that have gotten into, unfortunately, because of a legal issue, perhaps that's what led them to the disability, and they're receiving some sort of settlement. Or let's just say that child is now receiving an inheritance from a deceased grandparent. Those are going to be times when you really need a guardianship of the estate. Now, if it's just Social Security, you do not need a guardianship of the estate. They used to do that back in the day, but it's actually more problematic. So you really just only need a guardianship of the person. If you're unsure which one you need, that's why you hire an attorney. So you cannot do these documents on your own. You cannot apply for a guardianship on your own. You have to be represented by counsel. Not only do you have to be represented by counsel, but your counsel has to be certified in guardianships, okay? So when I tell people, when we have to talk to them, or they call the office and they say, I may need a guardianship, we always let them know they need to hire someone that specializes in guardianship and have their certification. Because if they have their certification, they can't even file things on your behalf, and they cannot appear for you in court on your behalf. So there is a certification process for attorneys to assist with guardianships. So a venue. So venue is basically where, when we talk about a potential ward, that's the person with an incapacitation, that's the alleged potential ward, the person that you're saying that needs to get a guardianship. So the venue, which means that where you're going to file your legal documents, is going to be where the potential ward lives. So let's say that you live in California. We've seen this before, where let's just say you live in California, your daughter, and you're trying to get guardianship over your mother. You live in California, but the ward actually lives here in Bexar County. You are actually going to file in Bexar County. So it always follows wherever the ward is, and we'll talk about that later, but venue is always proper wherever they reside, or where the potential ward is located when the application is filed, or where the principal estate of the potential ward is located. Now that's important. So when we talk about reside, it just means, again, where they're residents. So I had a guardianship the other day that was granted where a young lady had gotten to an accident in Miami, Florida, but she is a resident of Bexar County. She has her apartment here, her car here, her bank accounts here. So the proper venue for the guardianship application was going to be in Bexar County because she's a resident. Okay, let me see. Selection, hang on, let me make sure that that's the, all right. Selection of a guardianship. So the court will appoint a guardian after considering the circumstances of the incapacitated person's best interest. So here is kind of a list of who we look at first, who has priority. Appointment of preferences are given to 1, spouses, 2, nearest of kin, and 3, the court shall appoint an eligible of the individual that's incapacitated. The first person that has priority to serve is going to be the spouse. If the spouse, for whatever reason, is disqualified or cannot serve, then we will go to the sister. So that's important for people to know, because sometimes we have competing applications and they need to know the first priority is always going to be the spouse. The next is going to be the nearest of kin. So let's just say sister, wife doesn't want to do it, whatever it may be, then we're going to look at who the next of kin is. And then after that, let's just say there is no next of kin, we're gonna find a suitable individual, or we're gonna allow a suitable individual to serve. So the court will allow for joint appointments of incapacitated person if they are husband and wife. This is important because, especially for parents that are listening right now, you may be co-parenting with your ex, and you and your ex may get along very, very well. You both cannot apply for guardianship over your children. We do not allow for that. And there's a reason, okay, well, unless you're joint managing conservators or co-guardians already. There's a reason for that. Because when you file for guardianship and you're co-guardian with whoever it may be, your ex-husband, or you're trying to apply for it with your ex-husband, we have seen multiple times over and over and over again, well, you may get along now, but you may not get along in 6 months. And the only person that's going to have a problem, or let's just say you get along now and you think you'll get along in 6 months, but now you have to make a difficult decision on behalf of your child and you don't agree. There's going to be a problem. So we do not allow for ex-spouses to become co-guardians. Now, with that being said, you would have to have a discussion with your ex and say, do you want mom or dad to serve? So we will consider mom or dad, but not mom and dad together if they're divorced, because again, it just leads to problems down the road. In addition, you have to do certain filings together, like an annual report. We have seen times where we have appointed exes. I know I've seen this in my court where one of the, it was mother and father, they were divorced. Father refused to sign off on the annual reports. So what was happening is there were no annual reports that were submitted to the court. Because there was no annual reports that were submitting to the court, we then did a show cause on both of them, requiring them to both come into court and explain to me why there was an annual report. What turns out, dad was refusing to sign them. And so then dad got fined for all of this stuff. So it's very, again, so we don't allow for exes to be co-guardians. Now, if you're a co-guardian and you were already made a co-guardian in California or whatever with your ex, and then you transferred to Texas, we're going to honor that co-guardian. But if you are, again, when you're applying for the process and you are divorced, we won't allow for both parents to be co-guardians. Now, if you're married, we will allow. Now, of course, you may be married and then eventually get divorced. You want to contact an attorney at that point to see whether or not you want to move forward on your own or whatever it may be. But initially, when you start out this guardianship process, we will not allow for exes to be co-guardians. Yes. Yeah. Okay, I don't know how to, so I'm gonna have to stop share. Hang on just a second. Hang on, let me see. I have share screen. I don't have the interpretation button at the bottom. Hang on, I have English on. It is selected. And do I do mute original audio? Okay, so, okay. All right, let me see. Okay, so we just talked about the joint, who can appoint as, we can appoint as joint. Let's see, the eligibility of a guardian. So a person may not be appointed as a guardian. So this is important as well, because we may have a parent that wants to apply as a guardian, but just because you're a parent doesn't mean you're automatically qualified to be the guardian. So this is what we're going to look at when we actually look at the qualifications. So we have had situations, I've had situations where mom has applied for guardianship over her child, but she winded up having felonies and violent felonies. And so she could not, even though it wasn't against her own child, she could not become the guardian because she had those felonies in the background. So she had to then, it was her spouse, which would have been stepmom, that was able to apply for guardianship over her daughter. So, so who may not be appointed as guardian? So obviously if the person's a minor or another incapacitated individual, they cannot to be unsuitable. So it's not just that the person might have a felony. If let's just say they don't have a felony, but they have something in their background or allegations in their background or something in their background, the court says, no, this is not a good situation. We're not going to allow this person to become guardian. If they've been classified as having engaged in notoriously bad conduct, like a sexual offense, aggravated assault, injury to a child, abandoning or endangering a child, terroristic threat, or continuous violence against an incapacitated person or their family member. Now, this is important. And the reason why it's important is because when we talk about, I'll give you an example of a case where when I was working at Catholic Charities, I had mom and dad that were applying for guardianship. Dad, when he was younger, around 18, was involved in a gang. He had a violent assault against an individual with a weapon. She became pregnant with his first child. He completely turned his life around, and 20 years later wants to apply for guardianship of his child. Because of his background, he could not get bonded. He could not get a bond, and we'll talk about it in a little bit. So I couldn't approve him, the court couldn't approve him. So unfortunately, because of what had happened in his background, even though it was 20 years ago, it still affected his guardianship. So a lot of times attorneys they'll ask their applicant, the parent, for the criminal background, but they will also run a criminal background check on it, because JBCC, we'll talk about that in a second, they do run criminal background checks. So we're gonna know whether or not there's something that shows up on that individual's background. So it's really important to be honest with the attorney and ask yourself whether or not your criminal background is going to affect whether or not you can be the applicant. If there's a conflict of interest. So what does that mean? Let's just say that the child has an inheritance that's coming up that has a lot of money, but for whatever reason, let's say that they already have money and parent borrowed the money from the child. That's gonna be a conflict of interest, because you are now controlling their estate while you borrow money from the potential ward. So we look at a lot of times we see that with children. That's something that we're going to ask them. Do you owe your parents money? Did they make you a loan and you owe them money? Well, we're not going to want you to handle their estate if you owe them money. So if they've been disqualified in a declaration, if they lack required certification, we'll talk about that in a second. If they're non-residents and have not named an agent in the court to accept a service of process. So that is an individual, let's just say that when we talk about the daughter in California, she can apply for guardianship over her mother, but she's going to have to appoint a resident agent for service of process. So she doesn't appoint somebody as a resident agent here, she cannot be the guardian. Okay, and if you're applying to be a guardian of an incapacitated person who you've been found to be committed family violence against, clearly we're not going to allow someone that has abused their disabled child to then become the guardian, or the person that abused their mother that now has Alzheimer's. We're not going to allow them to become the guardian. Let's see. So guardian of the person, here's the rights and duties of the guardianship of the person. Again, this is over their person. The right to have physical possession of the ward and the duty to establish their legal domicile. You basically decide where they live. Are they going to live with you? Are they going to live in a group home? Where are they going to live? Nursing home, whatever. That's the guardian of the person makes those decisions. Ensuring the ward is cared for, supervised, and protected. Providing food, clothing, medical care, and shelter for the ward. The power to sign documents so that the ward can be employed. The power to consent to medical, psychiatric, surgical treatment, except for, again, that psychiatric commitment, which requires court approval. Psychiatric commitment, again, is going to be a whole nother process. Let's see. All right, guardian of the estate. One states an individual who has been named as the guardian of the estate is responsible for the estate. So again, let's say, for instance, the individual, maybe they have some sort of trust fund, whatever it may be. Let's just say they have some sort of inheritance that they're receiving. You're the guardian of the estate. You're basically responsible for managing that money. If it's a parent that has multiple rental properties, you are the one that's going to be collecting those rents that are due to the estate. So again, being able to make all the financial decisions on their behalf, just like they would have. Temporary guardianship. So a lot of times what we see is we see parents that would come into, and when I talk about a lot of times, I'm referencing my former employment with Catholic Charities. You would have parents that would come in and they would be very concerned that their child was turning 18 next month. They need to get a guardianship right now. They want a temporary guardianship. Well, the court doesn't allow for temporary guardianships in the normal process. So if your child's turning 18, that is not an emergency to the court. The time that, when we talk about temporary guardianships, it's the house is burning down. There's an absolute emergency. Let's just say your child turned 18, somebody opened up a credit card under his name, or now all of a sudden he's being abused by somebody, or something like that has happened where it's an emergency. Or let's just say your child turned 18, now they're in the hospital, somebody needs to make legal decisions on their behalf. That is what's considered an emergency. That is when we will grant a temporary guardianship. Otherwise, you have to go through the same process as everyone else. And again, go through the regular, normal guardianship process. So a temporary guardianship, a court can choose to appoint a temporary guardian if there's probable cause to believe the person requires immediate appointment of a guardian, like an emergency medical procedure or cases involving time-sensitive issues. Again, it's an emergency, the house is burning down, then we will appoint somebody. In addition, temporary guardianships don't last very long. They last for about 60 days, up to 180, and then sometimes even longer if there's conflicts or there's other things going on. But a temporary guardianship is basically to appoint somebody to become the guardian and them to be able to make decisions immediately. And then while they're in the process of applying for the regular guardianship process. So just so that you're aware, it doesn't last very long. Temporary guardianships are very, very temporary, and because they're an emergency. And we look at each one of our temporary guardianships that are filed. Every single temporary guardianship that is filed goes to the staff attorney, goes through me. And if it's something where I'm like, that's not an emergency, we're not going to allow for the temporary guardianship. We do have to hear it by statute, but it will be one of those things where, what's the emergency? If there's not an immediate appointment that's necessary, we're going to have you go back into the line and get in line with everyone else. Let's see, an appointment of a guardian. So, you can, right now, as a adult with capacity, you can appoint a guardian in your estate planning document. So I can appoint a guardian. Let's just say when I decide to sign my will, I want to appoint a guardian as well, just in case I ever become incapacitated, even though I've signed powers of attorneys. But let's just say they're not recognized, or and me being in this position, I know that that happens a lot of times. Even though power of attorney is signed, some institutions won't recognize them. But I want one specific child to become the guardian. I can do that. And what happens is when that person comes to court, and let's just say there's a fight between brother and sister, and they're both qualified, if the brother can show me that mom appointed him in this document, that's going to weigh heavily on the court. And I'm going to most likely rule in favor of the brother if they're both qualified to serve. Because again, that was the wishes of the individual when they were not incapacitated. So you can make a declaration in the event that you become incapacitated. The declaration must be signed or written in the person's handwriting and attested by 2 witnesses in the presence of the declarant. So kind of like a will. And you can also provide a self-proving affidavit. Let's see, service and notice requirements. So once let's just say you've decided, okay, there are no alternatives to guardian, you cannot understand documents that they're signing, there's no alternatives, we're gonna go ahead and go forward with the guardianship. there's a petition that is filed. It's called an application. And once that application is filed, the ward has to be physically served with that application. This is unlike any other area of law. Attorneys cannot take service for the individual. If you're living with your child, you become a guardian, you try to become a guardian of your child. There's the application that's filed. Your child actually has to be physically served. You cannot take service. You cannot take that document on behalf of your child. It has to be physically served on your child. Your child has to come to the door, has to take that away. Even if the child is wheelchair bound or in a bed, they still have to be served with the document themselves. How does that happen? Perhaps it's laid at their feet, whatever it may be, they still have to be served with that document. No one on behalf of that individual can take service for them. And why? It's important because when my husband right now can walk into a lawyer's office and say, I'm incapacitated, and start the whole legal process without me even knowing. If I were to be actually physically served with that document, I would be able to object, to appear in court, to hire a lawyer, do whatever I need to do. That's why it's so important, because guardianships, again, are one of the most restrictive things that you can do to an individual. You're taking away their rights to be able to make decisions for themselves, be able to marry, to be able to vote, be able to do all of these things on their own behalf. So it's really, really important. It's crucial in the law that these individuals have an opportunity to hire counsel or to speak up or do whatever they need to do if they feel that they do not need a guardianship. So they have to be served, personally served themselves. So understanding the process. Once the ward is personally served, we then appoint a court-appointed attorney called an attorney ad litem. The ad litem represents the proposed ward's interests. So they basically are that proposed ward's attorney. So let's just say it's your child. We're gonna use that example. Your child's turning 18, they got served. We have a court-appointed attorney. The court-appointed attorney will actually go out and meet with the child. I say child, right, but young adult. They will meet with the young adult, and they will have a conversation with them, and they will talk to them about the process. Okay, so your mom is now applying for guardianship over you. Are you okay? They explain what a guardianship is. Guardianship is your mom will be able to make decisions regarding your food, clothing, shelter, healthcare. Are you okay with your mom serving? Whatever it may be. So, but they have to go and meet with their client, and it's attorney-client privilege. Oftentimes when parents want to be in the same room as them, they cannot be in the same room when they're talking to their client because of undue influence. So it's attorney-client privilege. They go in and meet with and oftentimes, especially with individuals with disabilities, they're going to come back to the court and say, Judge, I tried to talk to her, tried to explain to her, but she was not able to understand. That's fine, but it's their job to be able to try to represent their client. If their client can't understand and says, I do not want a guardianship, I do not want mom to be a guardianship, it's the role of that attorney ad litem, again, because they're a court-appointed attorney to represent that potential ward. They're going to come into the court and say, my client does not want this guardianship. And they're going to explain, and they're going to fight on behalf of their client to not have a guardianship obtained. Let's see. So the proposed guardian, the person that's applying for guardianship, they must register with the JBCC. That is a requirement, and they must be certified before the hearing would have a certificate that's then filed with the court from the JBCC saying they completed it. In addition, we talked about the criminal background check. The JBCC has to have a criminal background check, and it's going to have to come back. If there's anything on that criminal background check, we will ask if it's something that we will ask in court. So just be prepared if you are applying, and even if it's a DWI from 20 years ago, or it's a minor possession, whatever it may be, if it's something that's on there, disorderly conduct, whatever it may be, if you have a criminal background, whatever it may be, it's going to come up in court. So be prepared to talk about it with the judge. Be prepared to talk about what had happened. Yes, Judge, I had a DWI 15 years ago. I served deferred adjudication. It's now, whatever it may be, like whatever it may be, you just be prepared to talk to the judge about it. So in addition to the criminal background check, the court-appointed attorney ad litem, there's also what's called a court investigator who works for our court, who basically does their own independent investigation. And it's really important. So the court investigator will go out to your house too, talk to you about the circumstances surrounding. They will not only talk to the applicant, the person that's applying for guardianship, they're going to talk to your ex as well. They're going to talk to your other kids. They're going to talk to everybody that's basically related to this individual to find out whether or not you are actually suitable to be the person. If there's any allegations that are come up, let's just say you're applying for guardianship, your ex doesn't agree with it, but they're not necessarily filing a Payee application. The court investigator is going to contact your ex. That ex is going to say, you know, this is why I don't think they're suitable. That's going to be reported back to the court. Okay. And those questions may come up in court. What, you know, these are the allegations we made. Can you speak to this? Whatever it may be, because it's, again, it's our role as a judge to ensure that the person that's being appointed as the guardian over an incapacitated individual is the best person to be appointed as guardian. Oh, and the court investigator also helps with less restrictive alternatives as well. They're going to assist your attorney in finding any less restrictive alternatives that may be out there. The hearing is set where the ad litem presents their findings. The potential guardian will be questioned by the judge, and the potential ward needs to be there as well. So especially with Zoom, we're having nothing but Zoom hearings. There's absolutely no reason why a potential ward should not be available in the Zoom hearing. There are times where we have individuals in a nursing home that refuse to be part of the hearing. I understand that, but if you're a parent and you're in the home with your child, it is going to be the preference of the court. If you're coming to my court, it's going to be the preference of the court to be able to have your child participate in the proceedings. What does that mean? They just need to sit there, and we need to see them. And sometimes they don't even sit there. Sometimes, but I will ask to see them. And the reason why that's important to the court is because, again, a lot of times you can be able to tell whether this person really needs a guardianship or not. And so it's really important. They are, by law, the court is required to have them there unless we find that their presence isn't necessary. Okay. And sometimes that happens because the person, you know, especially when we were actually physically going to court, the person cannot make it to court because they're bedbound. So in those type of situations, obviously, they cannot be there, and we're relying on their lawyers to let us know that. But if they can be there, it's always best to have them, especially with Zoom. You know, we have individuals, parents that will go and bring the phone to their child, and I can see that they're bedbound, and I understand that's why they're not there. Let's see. So a bond. So let's just say we get the whole process, and I go ahead and decide that mom is the best person to go ahead and apply for her son or to be the guardian of her son. There's a bond that's required, okay, by law. So what is the bond? Bond is like an insurance policy. It basically ensures that you're not going to do, after you become the guardian, you basically aren't going to abuse, neglect, exploit, take advantage of the person's finances after I've appointed you guardian. So once there is a bond, so the minimum bond for a guardian of the person for Bexar County is $11,000. You do not have to pay $11,000. People have a heart attack when they hear $11,000. You don't have to pay $11,000. You have to pay a portion of that. So there's a lifetime at the River City bonding. There's a lifetime bond with $350, and every year you still have your bond, that bond amount. But every year you have to be bonded, and it's important because again, let's just say I appoint you, but then you do turn out to do something that's horrible to the incapacitated individual. The bonding company will then revoke their bond, and you now owe the bonding company $11,000. Okay. When it's a guardianship of the person, we look at all the tangible assets, anything that can be taken or stolen, is what so let's just say that the person has a $500,000 estate. You know, when you add up all their bank accounts and, you know, all of the liquid assets, it comes out to $500,000. We're going to bond you we're going to have a bond of $500,000. So that's just for the guardianship of the estate. But again, for the guardian of the person, it's going to be $11,000 in Bexar County. So once I've signed the bond, you've come to court and I've signed the order, and then you've obtained a bond and I've signed the bond. That's the actual day that you become the guardian and you're issued letters of guardianship. Now, your letters of guardianship expire every single year. You have to do a couple of things. In order to get them renewed every year, you have to submit an annual report of condition and well-being for a guardian of the person. That is online on the Probate Court 2's website. If you have a guardianship of the estate, you have to file an annual accounting with the court. So guardian of person, you can file documents yourself on the annual report of well-being. Guardianship of the estate, you cannot file documents yourself. You're going to have to hire an attorney to assist you with the accounting of the estate every single year. And that is required. Again, both of those things are required by law. So if you're both the guardian of the person and the estate, you're required to do both, an annual report and annual accounting. And then you might have to pay a bond every year. It just depends on how you set up your bond to begin with. If you had a lifetime bond, again, with like River City, then you don't have to pay a bond every year. If you do not, you have to pay $100 every year. And you also have to have a visit from a court monitor. So a court monitor is an individual that's assigned by the court to go out and visit your child. And the reason why this is important is because we're required to by law. Okay, if you're a statutory probate court, so all the big counties are required to have a court monitor go and visit wards once they are under a guardianship. And why is that? Well, again, these are the most vulnerable people in our population. They cannot speak up for themselves. Because they cannot, we want to make sure that they're not being abused, neglected, or exploited. So we have court monitors that are sent out every single year. They'll call mom and they'll say, we're here to, we need to set up an appointment to visit Johnny to make sure he's doing okay. They will go out to the home and they will do an inspection to make sure that the fire extinguisher works, there's food in the fridge, that Johnny's, groomed and well cared for, whatever it may be. They're going to report it back to the court. There are circumstances, and I read every single one of those reports, every single one of them. And we have thousands of wards. So I read every single one of them. If there's something that raises a red flag, let's just say they go back and they say, room smelled like urine, or had bruises, or there was these concerns. The court's going to then follow up with the court investigator to find out what's going on. So this is a legislative update. So now there's compensation of guardians of Medicaid recipients. So there was an increase in compensation that a guardian may be paid if the individual has Medicaid. Let's see. So APS reporting requirements. This is just, this is essentially, I had the screen on here for individuals that have parents with disabilities or are incapacitated with Alzheimer's, dementia. Oftentimes we get family members that come to the court or come to an attorney and they say, my brother's abusing my mom. There is this, what this just talks about is that we are a mandatory reporting state, that, it's kind of like, if you think of child abuse, it's the same thing. You're required by law to report if you suspect. Now, when Adult Protective Services, not only do they protect individuals with Alzheimer's, dementia, elderly individuals, but they also protect individuals that are incapacitated. So they also protect people with special needs if you're over the age of 18. So if you have a reason to believe that somebody with special needs around you is being abused or neglected, you're required by law to report it to Adult Protective Services. They will then do their investigation, okay? So these reporting requirements to Adult Protective Services, again, is required by law. There are no exceptions. Just because you're a lawyer and it's attorney-client privilege, or even if you're a doctor or whatever it may be, they're still required by law if they suspect abuse or neglect of the person with an intellectual disability. Let's see, so that's just failure to report. There are penalties for failure to report. If, it can be anywhere from a Class A misdemeanor to a felony. Let's see, so that just talks about, so let's see. All right, and I'm gonna go ahead and share, we talked about earlier, I was talking about, really quick, alternatives to guardianship. There are other alternatives. If you're a practicing attorney and you're on the line right now, there are other alternatives to guardianships that are available. And as a parent, you're obviously welcome to read this as well. Let's see, let me see if I can find it. Let me try to find it really quick. Oh, one of the other things that I failed to mention was the certificate of medical examination. In addition to the application, you are required, the applicant is required to have a physician certificate of medical examination conducted on the potential ward. That is basically it's a form that doctors will fill out, and it has to be filled out completely by a medical doctor. And they tell us where the individual is at. So in other words, if the person has been diagnosed with IDD, autism, whatever it may be, they're also going to explain the level of functioning that person has, what they're able to do for themselves. Are they able to bathe, groom? Are they able to make medical decisions? Are they able to make all these decisions on their behalf? That's going to be filed with the, if it's not filed with the application, it has to be filed there shortly after, or yeah, and it can be conducted even before, but it can't be conducted too far ahead of time. And the reason why that's important is because that tells the court the level of functioning for that individual and whether or not they actually need a full guardianship. So if a person doesn't need a full guardianship, they can need a partial guardianship, and the court looks at that as well. And I don't know, I was trying to look for this, but I want to make sure, Allison, how much time do I have?
We have it going till 11, but we want to leave time for questions. So
Okay.
you're fine.
All right, let me go ahead and share this screen right here. So this is the physician certificate of medical examination that has to be completed by a medical doctor and submitted to the court. So I'm going to share this right now so you all can see. So this is the physician certificate of medical examination. So it will have the individual's name, the doctor's name, and when they examined the ward. They talk about the physical diagnosis and then the mental function, mental diagnosis, and the severity of the diagnosis. And let's see, so that he asked questions. So about dementia, if there's a possibility for improvement. Sometimes there is, sometimes there isn't. Okay, is the person oriented as to person, time, place, or situation? Where do they have a deficit? Short-term memory, immediate. So again, it asks very specific questions that will let the court know what the level of functioning is for this person. What are they able to do on their own? Can they make business, managerial, personal bank account, operate a motor vehicle, vote in election? You know, the doctor's going to sign off on this. Let us know where they at. Are they able to bathe themselves, groom themselves, etc.? Does a person have an intellectual disability, autism? You know, which one of these do they have? If they have something else, please explain what it is to me. You're making a determination. You're going to tell me what their level of IQ is. Again, this helps the court figure out whether there are, whether they need a full guardianship or partial. And it even says down here, what's their level of capacity? Are they totally capacitated, or are they partially incapacitated? Again, that's going to help the court decide whether they need a full guardianship or a partial guardianship. If the court sees that they're partially incapacitated, mom wants to go for full guardianships, but it's very clear to the court that they're able to do a lot of things on their own, we're not going to grant a full guardianship. Because again, we want to allow this person to keep as many rights as possible to be able to make decisions on their own or do things for themselves. Let's see. So that is the physician certificate of medical examination. Here's the less restrictive alternatives. This is on the probate. If you go to my website, the Probate Court 2's website, I have a lot of information on here. So we have court policies. So this is the ad litem manual. The ad litem manual, if you're a practicing attorney, even if you're not and you just want to review it, there is an ad litem manual that it's going to be less restrictive alternatives to guardianship. And again, it talks about some of the less restrictive alternatives to guardianship, which include, we talked about the supported decision-making agreement. Let's see, emergency protective orders that may happen because a person has mental health issues. Let's see, mental health. It talks a lot about mental health. Medical powers of attorneys again. And then that you can look at it, it says avoiding guardianship of the estate. It talks a little bit about the durable power of attorney. Trusts. So we see a lot of guardianship management trusts. Let's just say you have that individual again that came into an inheritance, or was, you know, you sue somebody because, let's just say there was an accident or whatever it may happen, you sued them on behalf of the ward. You have that money, you can always set up a trust, and a trust is a great way to avoid having a guardianship of the estate. So let's just say you have a special needs trust set up for your child, but you still need a guardianship over them. The court will not require a guardianship of the estate because the trust is being managed by someone else, and it's a special needs trust, and so that kind of it's basically an alternative to a guardianship of the estate, but you still will need the guardianship of the person if they need it. So it just goes into the different types of trusts that there are, again, that are going to be an alternative to guardianship of the estate. A community administrator. Now this we see with spouses. This is also an alternative to guardianship. So if you look at these documents, so it's on page 60, starts on 65. And goes, let's see, yes, it starts on 65. Let's see how far it goes. But it talks a little bit about those things as far as like trusts, putting money in the registry of the court. We see a lot of that money goes in the registry of the court if the person is actually a minor, and that's where they're getting guardianship of them. Let's see. So there's all sorts of other things that are out there. I just talked to you about the most common, especially for individuals with intellectual disabilities. Let's see. And that will go to page 73. Okay. So at this time, I'm going to go ahead and just open it up to questions. Allison, do I go to the bottom myself, or how did you want to do this?
Lauren's actually going to field the questions for us, so she'll ask the question and then you can address that audience.
Perfect. Are you ready for questions?
Yes.
Okay, awesome. We have a few that people typed in during the presentation. The first one is, can common law couples apply for co-guardianship?
No, they cannot. Unless they have proved to the court, they've gone through the whole process of proving that they're common law married, quote unquote, to the court, and that if you are just simply applying for guardianship, they're not going to be approved because they have not been found to be married. There's a whole nother process when you have to go through common law. People often call themselves common law, but they don't meet the statutory requirements of common law marriage. That's a whole nother separate process. So if you're coming to the court and you're claiming your common law, it's not going to be good enough for the court for you to become co-guardians. You're going to have to show the court that you are in fact married some way or another, that there was another proceeding in which you were declared common law married, and now you're showing the court that you're married. Because otherwise, this is not the proceeding to do that in.
Okay, perfect. And then someone, I guess in referring to the kind of the background requirements for guardianship, they said, what about being fingerprinted?
So fingerprinted, and I'm not sure what they're asking. I'm not sure if they're, because sometimes we get guardians that come in and say, I have a job as a teacher, and they're constantly running fingerprint background checks on me. Or I work for the federal government as a contractor. They did a fingerprint background check on me. Doesn't matter. We still have to go through the process of going through JBCC, and they have to run a criminal background check on you. Now, fingerprints are required if you are applying for guardianship of the estate, and it's over a certain amount. And of course, I cannot remember at this time what that amount is. So it's not required. Fingerprint background is not required if it's just a guardianship of the person. But if you're applying for guardianship of the estate over a certain amount, we're required, I can't remember off the top of my head what that amount is, you're required to go through the fingerprint process, background process.
Okay, awesome. Okay, the next question says, my son will be 18 next month. We're thinking about guardianship. If we were to get it, can he still apply for SSI? I know once 18 and applying for SSI and Medicaid, our income does not count, but does it change by becoming his guardian?
No, it doesn't. You can apply for it as soon as after you become the guardian if you'd like. You start the process now, you can wait till after you become the guardian, and it doesn't, again, it's going to be based off of the ward.
Awesome. Okay. Next question is, what kind of decisions can the ward make with a partial guardianship?
Depends. It depends on what the doctor tells us they're able to do. Not only do we take the doctors, so the doctor's physician certificate of medical examination is not the end all be all. If we hear testimony that, this person is able to, let's see, if this person is able to make managerial financial decisions on their own, and it's also the physician certificate of medical examination says that, and it says they're partially incapacitated. We elicit testimony from the ward, we elicit testimony from the applicant, we elicit testimony from other individuals. The court investigator reports that this person can make a decision regarding their own finances. That is something that we're going to allow the ward to continue to do. So it all depends on what that CME, everybody's different. So it just depends. Some individuals can make a decision regarding marriage, but then cannot make a decision regarding their finances. So it just depends on what the physician certificate of medical examination and the evidence shows and testimony shows.
Okay, great. Someone is asking if there is a list of lawyers from Hidalgo County who specialize in guardianship. I'm not sure if that's a question that you have the answer to, but I did want to address it.
I don't know. if you were to, I mean, I guess you would go to Hidalgo County, and they're going to have a bar association. I don't know. I wish I did. I don't know if their bar association is somebody you can contact. But I will tell you that, again, it has to be a guardianship certified attorney. So if you're going to Google someone in Hidalgo County, make sure that they have their guardianship certification. So it cannot just be someone. Oftentimes people will just go out there and get a lawyer that helped them with their cousin with a DWI. Like, that is not they have to specialize in guardianship, and they have to be certified, because again, you don't want to hire that lawyer, pay all this money, they show up to court and they're not certified and they can't even represent you. So you want to make sure that they've done guardianships before, that this is not their only guardianship case, and that they're certified in guardianship.
Perfect. Another question that says, I have a child with schizophrenia. Due to his behavior, he has had to move frequently. I live here. He has SSDI and SSI, and it is transferred from one payee to another. I am not sure if guardianship is the best thing for me or my son.
Right. And so mental health is a little tricky, because sometimes we will have individuals that will apply for guardianship over their child with mental health. And perhaps at the time, the child's not able to provide, they meet that standard of guardianship where they're substantially unable to provide food, clothing, shelter, or healthcare for themselves. But then 2 months from now, or even during the whole process where you're waiting to go to court, all those other things, they start taking their medication and they no longer need a guardianship. So that's something that you need to consider. Is the schizophrenia going to be something that's so debilitating on an everyday basis, even with medication or even with treatment, that they're not able to provide food, clothing, shelter, or care for themselves? That's something that you're going to have to discuss with your attorney, the physician. Again, that physician certificate of medical exam needs to be completed. So if it is, and we do see individuals that are that severe in their mental health, that they do need a guardianship, because even with medication and proper treatment, they still are not able to provide food, clothing, shelter, care for themselves. That's when, or manage their finances, that's when it's appropriate to have a guardianship. Again, it all depends on, it's case by case basis. So I really can't speak to one person. Now, if you do believe, again, even with the medication and therapy or whatever it may be, that they still aren't able to meet their basic needs for themselves, this person's not able to, with medication or with help, able to do all of those things on their behalf, then you may want to consider guardianship. But you really want to talk to an attorney at that point. And it's going to be, again, with the physician certificate of medical examination states as well. And of course, evidence, because if it tells me at that time that they were not able to make decisions, but then they come to court and they seem totally fine, that's going to be a huge red flag for me. And I wouldn't be comfortable with granting that guardianship if at the time they're able to make those decisions for themselves.
Awesome. Okay, a few more from the Q&A, and there were also some that people submitted during their registration process. So the next question is, does the Probate II website provide a list of recommended attorneys for applying for guardianship?
No, we don't. We never recommend it. There are attorneys that practice more than others in our court, of course. As a judge, we don't make recommendations. Now, I will tell you, if you look at the Probate Court II's website, let me see. Share my screen. If you look at the Probate Court II's website, there are a list of attorneys right here that say, certified guardian ad litem for Probate Court number 2. So it has a list of people that are certified in our court for guardian ad litems, but it also has a list of heirship attorneys, which just because they practice in this area doesn't mean they're guardianship certified. But a lot of these people that are going to be on the website that practice in front of the court, 90% of them on these 2 lists are going to practice as well in guardianships. So if that's where you want to start, you can, but we don't make a recommendation of a specific attorney, because again, we just don't feel it's ethical for the court to make that recommendation.
Absolutely. Okay, next question is, my son is 21, autism, nonverbal seizure disorder, 100% independent. I have tried going through Texas legal aid, but have no success. Where may I go to get guardianship if that is what I need and affordable to me?
Okay, so there's a couple of options. You have obviously Texas Rio Grande Legal Aid, which they've tried. Catholic Charities is also another organization that's going to provide, they don't provide pro bono, meaning it's not going to be free, but they provide low cost guardianships. I will tell you, I don't know if it's changed at Catholic Charities, but the cost for a guardianship ranges anywhere from $850 to $2,000. It just depends on where you're at as far as where you're at on the federal poverty guideline. Again, it could have changed over the years since I haven't been there for a couple years. There is a process though, if you're someone that is low income and you know, it's going to be up to the attorney to file what's called an affidavit of inability to pay. In those cases, when we talk about the court-appointed attorneys, the attorney ad litem, they're paid by the applicant. So in other words, if mom is applying for guardianship over her son, mom's going to have to pay the attorney. He's also going to have to pay the court-appointed attorney and pay all the court costs that are associated with it. Court costs are filing fees, etc. If you are someone that qualifies for an affidavit of inability to pay, you do not have to pay the attorney ad litem, and you do not have to pay the filing fees. So how much it costs to file, et cetera, and then you don't have to pay the annual reports every year when you file them. But again, you have to qualify for that. Again, there's income guidelines, or there's things that we look at. There's an affidavit that has to be filed, and it's going to be the attorney that's going to assist you with that. Catholic Charities, even though they assist you with filing those documents and you have an affidavit of inability to pay, they still require you to pay the minimum, which is $850. Now, they accept payments, et cetera, so that's an option. The other, I know that right now, there are the SALSA, which is the San Antonio Legal Services, that was part of the bar. They're now setting up a program to help people with guardianships as well. So those are really the three nonprofit organizations I can think of off of the top of my head. Otherwise, you would just have to talk to each attorney and ask them how much it would be to file a guardianship. Now, it's not always a flat fee because some guardianship cases are more difficult than others. The ones that take a little bit longer with filing and with getting everything together before you go to court are individuals. Let's just say you have an ex. Again, the ex is out of town. You can't find him. He still has parental rights, so he's going to have to be served. That's going to take a little bit longer because even if they can't physically serve him, they have to do it by citation by publication, which takes a little bit longer. Let's just say it's a daughter who has 6 siblings that all live in different places. Again, that takes a little bit longer to serve. So it just depends on your particular case. If you are husband and wife, you're applying for co-guardianship, this is your child, you don't have any other issues, meaning, you know, you don't have any other, they have to serve brother and sister, the same thing as well. If they have brothers or sisters that are over the age of 18. So let's just say this, you have one child, husband and wife apply. That case is a pretty simple, standard, straightforward case and moves on a little bit quicker. So that may be a little bit less money. So it all just depends on your circumstances, but you can always call an attorney and ask them for, you know, what they estimate the amount would be.
Fantastic. Yeah, and that kind of covered a lot of the questions that people asked of what is the cost of applying for guardianship. So thank you for that. That explanation. We have another question. It says, I work at Haven for Hope. Sometimes we file an 1102 to recommend that a client be investigated to receive a guardian. Can you talk about what happens when a person needs a guardian and does not have any friends or family? What should we consider as case managers when looking into if a client needs a guardian?
So there's a few things that we look at, and we do, what this individual is talking about is what's called an 1102 with the court. So let me see. I will share that with the rest of your audience. Let's see. Let me share my screen. Okay, so this document is on the probate court's website. It's on the general probate court's website. So we have general probate court's website and then specific court's website. So this is on the general probate court's website under orders and forms. And if you look under guardianship information letter, there's a document on here called an 1102. An 1102 is basically, I hereby request the court to investigate a need for guardianship of the following person. So the caseworker or whoever it may be could be a neighbor, whoever it may be, can fill out this form if they think that there is a person that's out there that needs a guardianship. So oftentimes we see this when the individual talked about working at Haven for Hope, that may be a person, again, with intellectual disabilities or mental health issues that they think actually needs a guardianship. So they fill out this form, they tell us where they're located, the individual that may need a guardianship, they tell us, you know, what we'll be investigating, the nature of the incapacitation, where the person is currently located. They fill out all of this information that goes to both courts. Either one of the courts will pick up this document and start an investigation. Sometimes it's not complete. We need your information on here because we need to talk to you. If there's not enough information on here for us to be able to determine whether to even start an investigation, we're going to contact you, the reporter, whoever's reporting it, to try to get more information to see whether or not this person needs a guardianship. So as far as when we talk about individuals from Haven for Hope, it just depends. Like, if we see somebody that is at Haven for Hope, that based off of the information that we received, looks that we need to start an immediate process. Now, what we're looking for, you have to understand, if the person we cannot find, what will happen is we first get the form. The staff attorney will then look at the form. Say this person appears to need a guardian ad litem appointed. The court then appoints a court-appointed attorney called a guardian ad litem. That guardian ad litem then picks up the investigation from the court. That guardian ad litem will then do their own investigation. The guardian ad litem is different from an attorney ad litem. Attorney ad litem, they're both court-appointed attorneys. The attorney ad litem is there to represent the potential ward, right? The person that we talk about under a guardian, or that's about to be under a guardianship, and they're there to represent their interests and say, no, they don't want a guardianship, or yes, they're good with mom being a guardian, whatever it may be. The guardian ad litem is actually there to advocate on whatever is best for the ward. So their best interest, even if they don't agree with it. So a guardian ad litem would be appointed on these particular cases to actually do the investigation and let the court know, Mrs. Smith at Haven for Hope, I went out and met with her, and it's very clear that she probably needs a guardian. So what they wind up doing is they file the application on behalf of Ms. Smith. The court process gets started. Then we appoint a guardian ad litem, Ms. Smith gets served, all these other things. Then it goes to the process. In that process, the guardian ad litem is going to do an investigation to try to find other family members of Ms. Smith. Because we not only get 1102s from Haven for Hope, we get 1102s from nursing homes where they have nearest of kin, they have information on nearest of kin. You know, we get it from neighbors where they have information on nearest of kin. So what the guardian ad litem is going to do is they're going to try to find the nearest of kin in order to have somebody that's become the guardian of this person. If for some reason they cannot find anyone, we will then have to go through the process of looking for either one, a private professional guardian. Well, not we, the guardian ad litem will then go through the process of trying to find a guardian, a private professional guardian to take it, or the Bexar County Guardianship Program. Now, what I need that person for Haven for Hope to understand, the person has to be funded. What does that mean? That means the person has to be able to have to apply for Social Security or Medicaid or something. So whether it's a vet that can go through the VA, whether or not, you know, so basically they have to almost be a citizen, because otherwise, if they cannot find funding for this individual, it's very, 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 very difficult, almost impossible for us to appoint a guardian. And the reason for that is because what's going to happen after this guardian takes over? How is this person going to be able to sustain themselves? How are they going to be able to live in a nursing facility? How are they going to be able to receive benefits in order to be able to eat every month? So those are the types of things that, just so that you're aware, if there's someone that's unfunded, it basically leaves the court's hands tied, because no one is going to want to be appointed the guardian if there's not any funding resource afterwards for that person to be able to be maintained. So again, if they don't have Social Security, they're not a citizen, they can't apply for Social Security. If they can't apply for Social Security, well, how are they going to be able to stay at a nursing facility or some other facility? If they don't, you know, again, so what you're looking at is the person able to be funded is what we talk about. Are they able to be self-funded, able to get Social Security, able to get Medicaid, VA benefits, whatever it may be? Do they have that resource? Because otherwise, even if we go through this whole process of the 1102, in the end, if nobody picks it up, then they won't be able to have a guardian. That's something you really, really need to think about when you're filling out these 1102s. Is it someone that has a possible funding resource to be able to maintain themselves?
Perfect. Thank you so much. Okay, a few more questions from here, and then I will try to get through as many of the pre-submitted questions as well. It says, I obtained guardianship over my adult child in another city, but now I reside in San Antonio. Do I have to do the guardianship process all over again?
No, but you do have to transfer the guardianship. And thank you for asking that question, because I was going to talk about it earlier. The guardianship follows wherever that individual was at. So if you were living in Harris County in Houston, it was outside the Bexar County, you're going to have to get it transferred over to Bexar County. And the reason why that's important is because we have to, because again, those people are these individuals are the most vulnerable in our population. We're going to have to make sure that he's doing okay. When you submit your annual report, if you were submitting it in Harris County, I can guarantee you Harris County is going to come back and say you need to transfer to Bexar County. That's what we do. So somebody started off in Bexar County, they move out to Kendall County, Comal County, Guadalupe County, wherever it may be. As the court, we're going to send you a letter and say you're required to transfer that guardianship to Kendall, Comal, wherever it is. And the reason for that is because we have jurisdiction over the individuals that are in our community. We can send out a court monitor, those people that are going to monitor and make sure that they're safe when they're in Bexar County. If you're out in Comal County or Guadalupe County, we cannot send a court investigator to go, a court monitor to go over there and make sure that your child is safe. That's going to be a huge problem for us. And the reason why it's a problem for us, if you think about liability, something happens to that individual in another county, we didn't go visit, we didn't transfer the case, guess who's going to be liable? It's going to be us. So we're going to make sure that it's transferred. So whatever county you move from, you're going to have to hire someone to transfer the guardianship. That does not mean that you have to pay for the whole guardian. The person's already been deemed incapacitated. So you don't have to go through the guardianship process. The same with successor guardians, okay? Let's say, for instance, mom was the guardian of the adult. Unfortunately, with COVID, we're seeing this a lot. I had an individual that his mom was a guardianship over his brother with Down syndrome. His brother with Down syndrome was in his 40s. Mom caught COVID. She wound up dying. So brother had to apply for successor guardianship over the son. So what happens when you apply for successor guardianship? Again, you have to get an attorney. They have to file those documents with the court. But son, the individual with Down syndrome, has already been diagnosed as a incapacitated person. So we don't go through that whole process again. But what we do is we look at the criminal background check of brother to make sure that he has a clean criminal background check. Or again, if he may have a couple of DWIs, whatever it may be, but it's not really bearing on the physical safety of the person with Down syndrome. That's going to be a consideration the court makes. And so we look at the criminal background check, and then we kind of go through the motions and sign off on the paperwork. So but you do need an attorney to assist you with that successor guardianship. Now, as far as the transfers, we have seen individuals do the transfers themselves, but I mostly see attorneys that assist with the transfer of the paperwork to the county. Okay,
perfect. Two more on here. It says, if an elderly individual over 75 is homeless with mental health issues resulting in the individual choosing to be homeless, although the individual is funded, has benefits, can a concerned individual file a suggestion of need for guardianship for the court to consider? Please note there is no known.
Yes, absolutely. Go ahead.
Sorry, it said, please note there is no known next of kin.
That's fine. You can always file an 1102. Now, you can always file an 1102. You can err on the side of caution, and we're always going to look into it. So it doesn't mean that you file an 1102 and then we do the investigation and we realize this person doesn't need a guardianship or whatever it may be. In addition, you don't need an actual physical address. It's helpful to have a physical address, but let's just say that every morning you wake up and you go to work, you see an individual on the same corner every morning, clearly talking to themselves, clearly disheveled or whatever it may be, and you think, oh my God, this person probably needs a guardianship. Go ahead and file that 1102. That is for the guardian ad litem to show up at that corner and start talking to this individual. So even if you don't have an exact address, that's okay. If you don't have next of kin, that's okay. Which, again, we want to know as much information as possible, but it's always best to err on the side of caution and go ahead and file that 1102 and let the court determine whether or not that we need to move forward.
Absolutely. Okay, it says, my son lives in Montana and I live here. Is it possible to be a guardian when you don't live in the same place? He is unable to live.
I don't know what Montana's, right, I don't know what Montana's state laws are, so I couldn't tell you. However, I will tell you that most states are very similar in guardianships process. In Texas, like I said, you can have a guardian that lives in California, but they have to, and they can apply for guardianship over their loved one here in Texas, but they have to have a resident agent appointed. Again, someone that lives in the state. Sometimes it could be, you know, maybe it's sister that's applying from California and brother lives in the state, then she has brother as the resident agent. Or she could have the attorney, the filing attorney as resident agent. That's fine, but the court does require, and I can't speak to every single court, but I know this court in particular requires a visit every quarter to the ward, because we don't want somebody that's appointed the guardian that hasn't gone to visit mom in 3 years and mom is being abused or neglected. So what we require is that they, if they're going to be the guardian and they live out of state, they're going to be required to visit mom every quarter just to make sure she's okay.
Gotcha. Okay, last question on here. It says, you said siblings over the age of 18 would be served if we were filing for guardianship. Will siblings living out of state also be served?
Yes, and they don't have to be served like, so there's a couple ways you can do it. Can you serve them physically? Yes. Or you can have them sign a waiver, especially if the family gets along and they all agree that mom and dad should become the guardians. They simply file what's called a waiver of service and notice. And that just basically, and the attorney files it with the court, basically saying that they're aware that mom and dad are applying for guardianship, they're in agreement, and they don't want to be notified anymore. And so it doesn't cost anything, simple, other than the filing fee, doesn't cost anything. It's simple process. So they don't have to actually physically be served. They can sign that waiver in lieu of. Now, sometimes the reason why it's important is, again, because what if brother and sister have some kind of information that we're not privy to, that, you know, mom's an abuser or whatever. I mean, then they have an opportunity to file a petition themselves or do whatever, you know, talk to the court and express their concern. So they do have to have notice of the proceeding. This brings me to another topic. Sometimes we have kids that their parental rights have been terminated. Their parental rights have been terminated, meaning that, you know, they were adopted and their parental rights were terminated by their biological parents. However, they have siblings. Those siblings need to be served still. As difficult as it may be, they still have to have notice of the proceedings and go through the whole process. If you don't know, I know he had a brother named Johnny Vasquez. I know the brother was named Johnny Vasquez. I do not know where he's at. We adopted this child when he was 3, so we have no clue where Johnny Vasquez is at. Then you have to do a citation by publication, okay? So they still, because those ties are still there, they still have to have notice of this, or they have to be served or get notice of the proceeding. So just so that you're aware, that still is something that has to happen. Same with bio parents. If they're biological parents and you've been their foster parent, but the parental rights were never terminated or whatever it may be, those individuals still have to get notice. Same with dad. Dad hadn't had contact with his child in 30 years, doesn't want anything to do with his child. Doesn't matter, still have to have service, still has to have notice of this proceeding. That's just a requirement by law. So I know that and that can make things a little more difficult, especially if you don't know where dad is or whatever it may be, but that is a requirement by law.
Okay, fantastic. Now I'm just going to try to get through as many of these pre-submitted questions as I can. The first one is, how early should we start the planning?
So the court doesn't want to see them too early because, again, I would say 6 months before their 18th birthday is a good time to go ahead and start it. You really don't want to start it any time before that, but 6 months before their 18th birthday is a good indicator. And of course, anytime, you know, you can even do it after their 18th birthday, you know, anytime. But if you want to start as early as possible, it's going to be about 6 months before the process.
Awesome. Okay, you've kind of already gone over those. It says, I have heard that some state programs will not qualify an individual for benefits if they are not 100% under guardianship. Is this true, and why? What is the difference between partial, like only power of attorney, or for medical living decisions and full guardianship? If you just want to kind of clarify that again for them.
I don't think I understand the question.
They
Say it again.
they said some state programs will not qualify an individual for benefits if they are not 100% under guardianship. Is this
Okay.
true, and why?
I
And
don't
then-
know about state programs, so I can't answer that question. I don't know, so I can't give that answer to that question.
Okay.
Okay, go
Not
ahead.
a problem. Can a person have 2 individuals set with guardianship?
Like 2 children that are under their guardianship? Is that what
That
that
I'm
is
not-
asking?
I have no
Well-
idea. This was a pre-submitted question, and that was the only comment. So,
So, yes, yes, they can have more than one ward that they are guardians over. There are private professional guardians that have multiple wards that are under their care, that they're the guardian over. So if that's the question, then yes, you can have more than one potential ward that is under your care.
great. Someone says, I have guardianship now, so will it be hard to get when she turns 18?
No.
Awesome. I think that is it. Everything else you've already really addressed. I guess I will turn it back over to Allison now to kind of finish it out.
Great. Well, thank you so much, Judge Vasquez, for your time this morning and for the pertinent information that you shared with us today. You attendees will be receiving an email with the survey later on. It will be asking you for ideas that you might have for future webinars, as well as how you enjoyed this one. This was recorded, and the recording will be made available the next week or so. So keep an eye out on our YouTube channel and our website to watch for Facebook and our Facebook page for future webinars. Sorry. If you know someone, or if you are needing to speak with a case manager yourself, please give us a call at the ARC of San Antonio at 210-490-4300 and ask for the case manager of the day, and they will support you in any way that they can. We thank you again for joining the ARC of San Antonio today, and we hope to see you at our next webinar. Take care and stay safe. Thank you, everyone.
Thank you. You take care.
You too.
Bye-bye.
Bye-bye.